Good morning, everyone. Thank you for being here this Saturday for our third lecture. I apologize for not being present in person today, but as always, you may reach out to me by phone, by email, or text message, and I will answer your questions as soon as I can. In the second half of Chapter 2, we will be discussing property of the bankruptcy estate, what are exemptions, and the automatic stay. The first question that we'll be discussing is what is property of the bankruptcy estate? And this question is really twofold. What is included in the estate and also what is not included in the estate. What is in the bankruptcy estate and what is not in the bankruptcy estate can be found in 11 U.S.C. section 541. Filing a bankruptcy petition creates what's called a bankruptcy estate. It's a new legal entity. It includes all legal and equitable interests of the debtor in property as of the filing. More on this later. Why is it important? Only property of the estate is subject to bankruptcy administration, which allows for a comprehensive settlement of the debtor's financial affairs. Chapter 7 versus Chapter 11 and 13. In Chapter 7, estate property is liquidated and the proceeds are distributed to creditors. In chapters 11 and 13, dealing with reorganization, estate property is not liquidated, but affects how much must be paid to unsecured creditors. And just as a recap, filing for bankruptcy creates an estate, the bankruptcy estate. That includes all legal and equitable interest of the debtor at the time of filing. This broad definition is crucial for a full settlement of the debtor's financial affairs. In Chapter 7, the estate's property is liquidated to pay creditors. In chapters 11 and 13, although the property isn't liquidated, its value affects the planned payment to creditors. Property of the bankruptcy estate can be found in 11 U.S.C. section 541A. And I've created this chart to go over the big ticket items within section 541A. This is a non-exhaustive list, and I encourage you to look up the code section itself for a full review of what is part of the bankruptcy estate. The first category is debtor's interests. All legal or equitable interest of the debtor in property as of the commencement of the case. Legal interest refers to the formal ownership of the property, for example, holding title to a car, while equitable interests refer to the right to benefit from the property. Let me give an example. A debtor holds title to a car, that's a legal interest, and has a right to receive rental income from a property owned by a trust. That's an equitable interest. Community property. If the debtor is married, any property that is jointly managed or liable for debts is included in the bankruptcy estate. A married couple owns a joint checking account that is managed by the debtor. That would be included in the bankruptcy estate. Recovered property. If the trustee recovers property that was improperly transferred before the bankruptcy, it becomes part of the estate. Here's an example. The trustee recovers money from a fraudulent transfer the debtor made before filing of the bankruptcy. Preserved or transferred interests. Certain property interests are preserved for the benefit of the state or transferred to it, like avoiding a fraudulent transfer or setting aside a preferential payment. For example, if a debtor transferred money to a relative right before filing to keep it away from creditors, that money can be brought back into the bankruptcy estate. Here's another example. A debtor pays back a friend a large sum of money just before filing for bankruptcy, and the court orders that money returned to the estate to be divided among creditors. Property acquired after filing. If the debtor acquires property like inheritance or a divorce settlement within 180 days of filing, it is included in the bankruptcy estate. This ensures that any sudden windfall after filing still benefits creditors. An example, the debtor inherits money from a relative within 180 days after filing for bankruptcy. This would be included in the bankruptcy estate. Proceeds and profits. Any income or profit from property in the estate, like rent from a rental property, is also included. An example, a rental property owned by the debtor generates rent after filing for bankruptcy. Those rents are part of the bankruptcy estate. Post-commencement acquisitions. Any new property the estate acquires after the case begins, such as property that was in the process of being recovered or settled, can become part of the estate if it relates to actions that started before the bankruptcy. Here's an example. The debtor was involved in a lawsuit before filing for bankruptcy, and the settlement from the lawsuit finalized after filing. This becomes part of the estate because the lawsuit was an ongoing asset of the debtor before filing bankruptcy. The general rule is that post-petition property usually does not become part of the bankruptcy estate. This is property acquired after the filing of the petition. There are exceptions. Post-petition income of individual debtors in Chapter 11 and 12 and 13 are included in the bankruptcy estate. Remember, Chapters 11, 12, and 13 are reorganization bankruptcies. Post-petition income must be included in the bankruptcy estate in order to make feasible a plan under Chapter 13 and 11. And there are other notable exceptions we've already discussed in the prior slides, but just to reiterate, property recovered by the trustee is part of the bankruptcy estate. Property preserved for the estate is also within the bankruptcy estate. Property acquired within 180 days post-filing, for instance, the inheritance, is part of the bankruptcy estate. Proceeds and profits from estate property also included in the bankruptcy estate. Remember the rental property example. Property acquired by the estate after filing is also part of the bankruptcy estate. Property not in the bankruptcy estate can be found in 11 U.S.C. Section 541, subsection B. Below, I created a chart that outlines the big-ticket items that I want you to be aware of. Obviously, this is not an exhaustive list. I encourage you to look at 11 U.S.C. Section 541B for a comprehensive listing of everything that is not part of the bankruptcy estate. Let's go over the big three for me. Powers held for others. Powers that the debtor has that are meant to benefit someone else do not become part of the estate. Here's an example. The debtor manages a trust for a relative, but that money belongs to the relative, not the debtor. Therefore, it is not part of the bankruptcy estate. Terminated leases. If a lease ended before the bankruptcy filing or during the bankruptcy case, the debtor's interest in that lease is not part of the estate. This means if you're renting an apartment and the lease ended before you filed for bankruptcy, that lease is not included. Here's an example. The debtor's lease on a commercial property expired before filing for bankruptcy, or the debtor's apartment lease ended during the bankruptcy. It would not be part of the bankruptcy estate. Employee contributions, and we will discuss this at length in future lectures. Money withheld by employers for employee benefits like a 401k contributions or health insurance is not part of the estate. An example, the debtor's employer withheld money from their paycheck for a 401k plan. That is not part of the bankruptcy estate. Now let's discuss the first case, Patterson v. Shumat. Here are the facts. Joseph Shumat worked at Coleman Furniture Corporation and was a participant in an ERISA qualified pension plan valued at $250,000. ERISA stands for the Employee Retirement Income Security Act, federal law that protects people in pension and health plans. It requires plans to provide clear information to participants and sets rules for those managing the plans to act in the participants' best interests. ERISA also ensures there is a process for participants to claim their benefits and includes an anti-alienation clause that protects pension benefits from being taken by creditors. Both Coleman Furniture and Shumat filed for bankruptcy, and Shumat's case was converted to Chapter 7. The trustee, Patterson, sought to include Shumat's interest in the pension plan as part of the bankruptcy estate. Patterson v. Shumat, the issue and holding. The key issue was whether Shumat's interest in the ERISA qualified pension plan could be excluded from the bankruptcy estate under Section 541C2. Yes, the Supreme Court ruled in favor of Schumat, holding that the anti-alienation provision in the pension plan is enforceable under non-bankruptcy law. This means Schumat's interest in the pension plan was not included in the bankruptcy. Taking a look at Section 541c2, the exact language, quote, a restriction on the transfer of a beneficial interest of the debtor in a trust that is enforceable under applicable non-bankruptcy law is enforceable in a case under this title. Now remember, ERISA plans include an anti-alienation clause that protects benefits from being taken by creditors. This is a restriction on transfers, in other words. This restriction is also based on non-bankruptcy law, and the court essentially stated that it must be respected under Section 541c2. Patterson v. Schumat, the reasoning. The Supreme Court determined that, quote, applicable non-bankruptcy law in Section 541c2 includes federal law, such as ERISA, in addition to state law. The anti-alienation provision in Schumat's ERISA qualified pension plan was deemed enforceable, allowing his interest to be excluded from the bankruptcy estate. The court emphasized the importance of consistent treatment of pension plans, ensuring that they remain protected under ERISA even in bankruptcy. Now let's move on to the next case, Carpenter v. Reese. Todd Carpenter received a lump sum Social Security payment of $17,165 for retroactive benefits and deposited that amount in a bank account. After filing for Chapter 7 bankruptcy, Carpenter claimed this payment as exempt under 42 U.S.C. Section 407, which essentially protects Social Security benefits from being subject to bankruptcy laws. The bankruptcy trustee, Charles Reese, objected, stating that the payment should be part of the bankruptcy estate. The issue was whether the lump sum Social Security payment received by Carpenter could be excluded from the bankruptcy estate under 42 U.S.C. Section 407, which prohibits Social Security benefits from being subject to bankruptcy laws. The court ultimately ruled that Social Security benefits, including those already received, are excluded from the bankruptcy estate, affirming that Carpenter's payment was protected under Section 407. Carpenter v. Reese, the reasoning. 42 U.S.C. Section 407 explicitly protects Social Security benefits from being included in the bankruptcy estates, ensuring that these benefits remain fully shielded from creditors. The court interpreted Section 407 as an exclusion, meaning that Social Security benefits do not even enter the bankruptcy estate, rather than simply being an exemption the debtor must claim. Now, that's an important distinction. It's not even part of the bankruptcy estate in order for it to be exempted. The decision was supported by earlier rulings, such as In re Bruin, which confirmed that Social Security payments are automatically protected from being included in the bankruptcy estates. This ruling reinforces Congress's intent to protect Social Security benefits from creditors, ensuring the recipients can rely on these funds regardless of their bankruptcy status. Our next topic in Chapter 2 are exemptions. This is a very important area of bankruptcy law. So if you have any questions, please write them down and we can discuss when I return. Or alternatively, you can also email me. Now, exemptions. What are exemptions and how do you apply them? Let's discuss in this section. Understanding exemptions. State explanation. Exemptions protect certain debtor assets from being seized by creditors, allowing individuals to retain essential property even after bankruptcy. The main purpose of an exemption is to prevent debtors from losing everything and help them recover financially. These protections are available only to individual debtors, but similar exemption laws exist outside of bankruptcy in each state. Exemptions in bankruptcy. In bankruptcy, exemptions are governed by Section 522 of the Bankruptcy Code. Debtors have the option to choose between their state's exemption laws, or what we call scheme, or federal exemptions under Section 522D. Once property is claimed as exempt, it is removed from the bankruptcy estate and protected from creditors. As an example, imagine a car that is valued at $5,000. Supposing there is a state exemption that protects vehicles up to $5,000. The debtor applies that $5,000 exemption to his car that is valued at $5,000, therefore excluding it from the bankruptcy estate. State versus federal exemptions. State exemptions can vary significantly. Often they favor homeowners with generous homestead exemptions. Federal exemptions, on the other hand, aim to offer more equality, particularly for debtors without real property, by allowing a portion of the unused homestead exemption to be applied to other property. In some states, debtors do not have a choice between state and federal exemptions, as those states have opted out of the federal scheme in its entirety. Federal exemption amounts are periodically adjusted to keep up with inflation. The homestead exemption in the federal code is found under Section 522D1. I encourage you to take a look at that code section, and I also want you to look at the California homestead exemption and become familiar with the differences and similarities. Now let's move on to our first case regarding exemptions, Law versus Siegel. And here are the facts. Stephen Law filed for Chapter 7 bankruptcy, claiming a $75,000 homestead exemption on his house. Law listed a fraudulent lien on the property, attempting to shield it from creditors, but the trustee, Alfred Siegel, discovered the fraud. This resulted in significant litigation costs, with Siegel incurring over $500,000 in attorney fees. Law v. Siegel, issue and holding. The key issue was whether the bankruptcy court could surcharge Law's homestead exemption to cover Siegel's attorney's fees due to Law's fraudulent conduct. The Supreme Court ruled that exempt assets, such as Law's homestead exemption, cannot be used to pay administrative expenses, regardless of the debtor's misconduct. Law v. Siegel reasoning. While bankruptcy courts have broad authority, they cannot override specific provisions of the Bankruptcy Code, such as those protecting exempt assets. Section 522 explicitly protects exempt property from being used to pay administrative expenses, and the courts must adhere to these statutory protections. The court highlighted that the Bankruptcy Code's detailed exemptions and limitations do not allow courts to create additional exceptions based on equitable considerations. Now let's move on to our next topic in Chapter 2, the automatic stay. And as I've said numerous times during our class, the automatic stay is really the backbone of the Bankruptcy Code. It is what makes the bankruptcy code feasible and possible. And we will discuss three topics in regards to the automatic stay: scope, exceptions, and relief from and termination of the automatic stay. Our first topic about the automatic stay is the scope of the automatic stay. The automatic stay can be found in 11 U.S.C. Section 362. Be familiar with this code section. If you do end up practicing bankruptcy, you'll be referring to Section 362 quite often. The automatic stay is a critical protection in bankruptcy. It is designed to offer immediate relief to debtors from their creditors' collection efforts, for instance, foreclosure. It acts as a self-executing injunction that begins the moment the bankruptcy petition is filed. The stay stops almost all creditor actions, providing the debtor time to organize their financial affairs without external pressures. The purpose and function of the stay. The legislative history emphasizes that the automatic stay is a fundamental debtor protection under the bankruptcy laws. It offers a crucial period where the debtor is protected from creditor harassment and can focus on reorganization or liquidation plans. This period is not just for the debtor's benefit, it also ensures that all creditors are treated fairly by preventing any one creditor from getting an unfair advantage. Exceptions and strategic use of the automatic stay. While the automatic stay is broad, it's not without exceptions. Certain activities, such as child support collection and criminal proceedings, are not halted by the stay. An interesting and sometimes controversial aspect is the strategic or offensive use of the stay by debtors. This strategic use can sometimes lead to a debate over whether such actions constitute a bad faith filing. Judicial interpretation of the stay's scope. There has been significant judicial debate on what constitutes an act under Section 362, especially regarding passive conduct. Most courts viewed passive conduct as prohibited, but a minority argued otherwise. The Supreme Court eventually resolved this by siding with the minority view, which has implications for how the automatic stay is applied in various situations. City of Chicago v. Fulton. Here are the facts. In this case, the City of Chicago impounded vehicles due to unpaid fines. When the vehicle's owner filed for Chapter 13 bankruptcy, they requested the return of their vehicles, arguing that the city's refusal violated the automatic stay imposed by the bankruptcy court. Both the bankruptcy courts and the Seventh Circuit ruled in favor of the debtors, holding that the city's refusal to return the vehicles was a violation of the stay. The Supreme Court agreed to hear the case to resolve differing interpretations among the lower courts regarding the scope of Section 362A3. The issue and holding in City of Chicago v. Fulton. The central issue in this case was whether a creditor's mere retention of debtor's property after a bankruptcy petition is filed constitutes a violation of the automatic stay under Section 362A3. The Supreme Court held that simply holding onto property does not violate the automatic stay. The court clarified that Section 362A3 requires an affirmative act that alters the status quo, not merely the retention of property. City of Chicago v. Fulton. The reasoning. The court carefully analyzed the language of Section 362A3, focusing on the meanings of key terms like stay, act, and exercise control. It concluded that the provision prohibits actions that disrupt the status quo, not the mere retention of property. The court also highlighted the role of Section 542, which explicitly governs the turnover of property to the estate. If mere retention were covered under Section 362A3 of the automatic stay, it would render Section 542 largely redundant, which the court deemed illogical. Finally, the court considered the legislative history, noting that the 1984 amendment to Section 362A3 of the automatic stay was not intended to impose a turnover requirement, but rather to extend the stay to include control over intangible property. Our next topic under the automatic stay are exceptions to the automatic stay. The automatic stay and exceptions. The automatic stay under Section 362A is designed to provide a broad protection to debtors. It essentially freezes most actions against them once they file for bankruptcy. However, Section 362B outlines specific exceptions to this stay, recognizing that certain actions must be allowed to continue either because they are socially desirable or due to pressure from interest groups. These exceptions ensure that while the debtor is protected, other important actions, such as criminal proceedings or enforcement of certain family law obligations, such as child support, can still proceed. Key exceptions under 11 U.S.C. 362, the automatic stay. The Bankruptcy Code allows certain actions to proceed even after a debtor files for bankruptcy. As discussed previously, family law obligations like child support and spousal support are so essential that they are excluded from the stay. As mentioned previously, criminal proceedings are another significant exception, ensuring that a debtor cannot use bankruptcy to escape criminal prosecution. Additionally, the IRS retains its authority to carry out tax-related actions, which is critical for the government's ability to collect revenues. Government agencies also retain power to enforce regulatory and police actions, ensuring that public safety and welfare are not compromised by a debtor's bankruptcy. Legislative and policy considerations. The exceptions to the automatic stay are not just about legal technicalities. They reflect the broader social policies and the influence of special interest groups on legislation. While some exceptions are clearly aligned with the public interest, such as those for criminal proceedings or family support obligations, others may be the result of lobbying by powerful groups. As you study these exemptions, think critically about whether they strike the right balance between debtor protection and the need for certain actions to continue, or if they tilt too much in favor of certain interests. The SEC versus Brennan. Facts. In this case, the SEC was attempting to enforce a judgment against Robert Brennan, who had created an offshore trust to shield assets from creditors. After a judgment was issued against him for securities fraud, Brennan filed for bankruptcy, complicating the SEC's effort to recover the funds. The SEC, believing Brennan still controlled the trust, obtained an order requiring Brennan to repatriate the assets, which became the central issue of this case. The SEC versus Brennan, issue and holding. The central legal question in this case was whether the SEC's repatriation order violated the automatic stay provisions of the Bankruptcy Code. Specifically, the court had to determine if the order was an attempt to enforce a money judgment, which would be barred under the automatic stay. The court held that the SEC's order did violate the stay because it was essentially an effort to enforce a prior money judgment against Brennan. The reasoning behind SEC versus Brennan. The court's reasoning focused on the balance between the broad protections offered by the automatic stay and the exceptions for government regulatory actions. While the government can pursue certain actions under its police powers, the enforcement of money judgments is still subject to the automatic stay. In this case, the court found that the SEC's actions crossed the line into enforcing a money judgment, which is not permitted under bankruptcy proceedings, without violating the automatic stay. In re Commerce Oil Company, the facts. This case involves Commerce Oil, which was accused by the state of Tennessee of violating environmental regulations by illegally discharging brine. The state assessed penalties and Commerce appealed while simultaneously filing for bankruptcy, which automatically stayed the proceedings. The issue at hand is whether Tennessee's actions to enforce these penalties fall within the, quote, police power exception to the automatic stay provisions under the bankruptcy law. In re Commerce Oil Company, issue and holding. As I stated previously, the key legal question here is whether Tennessee's attempt to assess penalties for environmental violations is exempt from the automatic stay imposed by Commerce Oil's bankruptcy filing. The court ultimately held that these proceedings are indeed exempt under the police power exception, allowing the state to continue its efforts to enforce environmental laws. In re Commerce Oil Company, the reasoning. The court's reasoning centered around the distinction between actions that are primarily regulatory, those aimed to protecting public safety and enforcing laws, and those that are primarily for collecting debts. In this case, Tennessee's actions were seen as enforcing public policy, specifically environmental protection, which falls squarely within the police power exception, allowing the state to proceed despite the automatic stay. The court rejected the argument that this would unduly burden the debtor's estate, emphasizing the importance of environmental law enforcement. Now we will discuss the final topic in regards to the automatic stay, that is relief from and termination of the automatic stay. Relief from and termination of the automatic stay. The automatic stay, though broad, is not absolute. Creditors can seek relief from the stay under certain conditions outlined in Section 362, subsection D. Relief is available if a creditor can demonstrate cause, such as a lack of adequate protection. If the debtor has no equity in the property and the property isn't necessary for reorganization, relief should be granted. This process primarily comes into play with secured claims, which we will explore more deeply in Chapter 4. Termination of the automatic stay. The stay automatically terminates in specific scenarios, such as when the property is no longer part of the estate or when the case is closed. Even after termination, creditors might still be restricted from collection efforts due to a discharge injunction, which replaces the stay and prevents collection on discharged debts. Addressing debtor misconduct. To combat serial filings, meaning multiple bankruptcy filings, meant to abuse the stay, Congress has added provisions that limit the stay's effectiveness for repeat filers. The interpretations of these provisions vary, particularly regarding whether the termination applies to the estate property, leading to different court rulings. Impact of debtor ineligibility. If a debtor is ineligible, for example, lacks the required pre-petition counseling certificate, there's debate on whether the automatic stay applies. The Second Circuit ruled that even an ineligible filing triggers the stay. The court suggested that instead of dismissal, other actions like striking the petition could be considered, allowing for flexibility in how these cases are handled. Writing exercise, sample exam question. For the remainder of today's session, I'd like you to begin preparing for exam writing. I've crafted a custom fact pattern to give you insight into my exam writing style and structure. Please use the remaining time to carefully read through the fact pattern provided and answer the questions on the upcoming slides. Treat this as if you were in an actual exam. No notes, no books. Place yourself in an exam-like situation and provide a well-structured essay response to each question. Remember to address the issue, state the applicable rule, and provide a thorough holding reasoning in your essays. When I return, we will go over a sample answer I've written in response to this fact pattern so you can compare your approach and identify areas for improvement. Please note that I will use this exercise to track attendance for today's class. Sample exam question fact pattern. Jack Martin, a successful entrepreneur, filed for Chapter 7 bankruptcy in January 2024 after his tech startup TechWave Inc. collapsed due to market downturns and a costly lawsuit. Jack's assets include a house valued at $1.2 million, a luxury car worth $80,000, and several investments in tech stocks. He also has a $500,000 retirement account under an ERISA qualified pension plan, which he believes is protected from creditors. Before the bankruptcy filing, Jack made several financial maneuvers. In November 2023, he transferred $50,000 to his brother, claiming it was a repayment for a loan that had no formal documentation. Additionally, Jack created a trust for his children, funding it with $150,000 in tech stocks to ensure their future security. Jack's wife, Emily, owns a thriving online business, and they jointly hold several properties, including a vacation home in Hawaii. Creditors are pursuing her assets, claiming community property rights in California. In February 2024, Jack inherited $200,000 from a distant relative. He immediately used the funds to pay off some personal debts, assuming that since the inheritance occurred post-filing, it would not be included in the bankruptcy estate. Complications arose when the bankruptcy trustee discovered the transfer to Jack's brother and the trust fund for his children. The trustee is seeking to recover these assets, claiming fraudulent transfer. Jack's attorney argued that these transfers were made in good faith and should not be included in the estate. Furthermore, the trustee is also seeking to include Jack's inheritance and rental income from his vacation home as part of the estate, despite Jack's objections. Meanwhile, Emily argues that her business and the jointly owned vacation home should be protected from creditors since they are her separate property, or so she argues. She also claims that the Hawaii vacation home should not be subject to California's community property laws. To complicate matters, the IRS is pursuing Jack for unpaid personal taxes that have accumulated over the years. Jack hopes the automatic stay will halt these collection efforts, but the IRS argues that the tax collection should resume immediately due to the nature of the debt. Finally, Jack is concerned about his luxury car being liquidated, as he needs it for personal transportation. He hopes to use the wildcard exemption under Section 522(d)(5) to protect this asset despite its high value. Sample exam question, essay question. Discuss the issues surrounding the inclusion and exclusion of assets from Jack Martin's bankruptcy estate, considering the following. Number 1. The application of 11 U.S.C. 541 concerning the inclusion of Jack's assets, particularly the ERISA qualified pension plan, the post-petition inheritance, and the proceeds from the jointly owned vacation home. Number 2. The trustees attempt to recover the $50,000 transfer to Jack's brother and the $150,000 trust fund created for his children, addressing potential fraudulent transfer claims under the bankruptcy code. Number 3. The protection of Emily's business and the vacation home from creditors, focusing on community property rights in California and the impact on jointly owned assets. Number 4. The IRS's position on resuming tax collection efforts despite the automatic stay and how this interacts with the protections afforded by the bankruptcy code. Number 5. The use of exemptions, including the wildcard exemption, to protect Jack's luxury car from liquidation. Provide a reasoned analysis based on statutory provisions, case law, and policy considerations.